All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Ryan D. Lambert, Judge, presiding. All persons having business before the court is all near to attention and you will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, thank you, Charlie. So that's one advantage of being a chief judge. I always know where my seat is. All right. Good afternoon. Welcome to another session of oral argument before the 5th District Court of Appeal. Had to start later this afternoon because we usually do it at 9 o'clock, but Judge Edwards and I were in a scintillating District Court of Appeal Budget Commission meeting for a few hours, so here we is. As the Marshal indicated, I'm Judge Lambert, Chief Judge. I'll preside over the two oral argument cases that we have here today. On the panel with me to my right and to your left is Judge Jim Edwards, and to my left and your right is Judge John Harris. So each side will have 20 minutes for their argument. We are being videoed and all that, so keep that in mind as you make your arguments. People can actually watch you and watch, later on what you've said. If you have any type of electronic devices, phones or what have you, please put those in either the mute or off position now so that we can, disturb your opposing counsel or yourself or the court by them going off during the course of your oral argument. All right, as indicated, two cases today. Actually, both are criminal appeals, or from criminal cases. Our first case is 21-2733, Jamal Malik Brown versus the state of Florida. So, counsel, if you're ready to go, you can proceed. And we'll reserve 5 minutes unless you tell me you want a different amount of time.
That is actually the amount I was going to ask for, Your Honor. That was the amount I was going to ask for.
Well, there you go. It's already on the clock, so it makes my job easier.
May it please the court, counsel. My name is Ed Weiss. I'm here on behalf of Mr. Brown, the appellant. We are here in a case in which 3 issues were raised. Unless questions are asked on the third issue, which is the discovery violation, I'm going to predominantly focus on the first 2. However, all 3 issues are, for the most part, interrelated in that they all come down to the foundational argument that Mr. Brown was denied his right to counsel under the 6th Amendment of the U.S. Constitution in Article 1, Section 16 of the Florida Constitution. And there are certain quotes in the trial that I think really come to mind when we address, especially the first issue, which then blends into the second issue. Because had counsel been appointed, the second issue would not exist. And the first is when the trial court told him that decision was already made. If I had the original obligation, you would not be representing yourself. If I had to do it all over again, you would not be representing yourself. There can be no doubt that Mr. Brown unequivocally requested counsel at the time just before the veneer walked in. Instead of focusing on the right to counsel, the trial court and the state both focused on whether the case needed to be continued. That is a distinct and independent issue that does not go to the other one. Mr. Brown, under the Constitution, and we have a rule that goes to it in Florida Rule of Criminal Procedure, that says the trial court shall reoffer counsel before any critical stage on a person who's already requested to represent themselves. The trial court didn't actually offer counsel. The trial court asked Mr. Brown, do you still want to represent yourself? Without hesitation, he said no. They then had a discussion.
You're saying the rule gives the defendant basically a free continuance if he waits until the last minute and requests counsel on the day of trial?
No, it does not. And it doesn't mean just because you wait till the last second that you have to have a continuance. As the United States Supreme Court said in U.S. v. Chronic, a last-minute appointment of counsel does not automatically always have to mean a continuance. The trial court can deny a continuance when it appoints counsel at the last moment. We in Florida have a standard where if a continuance is requested, one of the factors to be considered is, did the defendant contribute to the delay or the problem that required the continuance? But whether or not a continuance should be granted is independent of whether or not he has a right to counsel. He had standby counsel, and standby counsel had been appointed, I believe, for about 3 years.
But wasn't prepared to try the case.
And that's on standby counsel's fault. I mean, there's no evidence in the record that says that Mr. Brown was refusing to supply standby counsel discovery. There's nothing to indicate Mr. Brown was not cooperative with standby counsel. In fact, there's evidence to show that he was cooperative. Standby counsel was helping schedule the hearing. Standby counsel helped schedule a deposition that Mr. Brown conducted. The case was continued, I believe, in June of 2021 so that Mr. Brown could meet with standby counsel. When they came back in August, standby counsel said he met with him. So there wasn't a lack of cooperation between standby counsel and Mr. Brown. Why standby counsel decided to not look at any discovery whatsoever, I have no idea. But that should not control whether or not Mr. Brown has a constitutional right to counsel. Standby counsel not doing anything does not negate the constitutional right to counsel. And that's what we're here for. He specifically said that. And instead of focusing on whether he wanted to exercise his right, which he has, the court focused on the continuance. And over, Mr. Brown continued to say, I want counsel. He even at one point during the jury selection said, if there's counsel ready to represent me here, what's the problem? And everyone just focused on the continuance. And the case at hand is very much similar to what happened in Brown. In Brown, you had a defendant who was represented. He won an appeal, came back, wanted to represent himself. He represented himself for 18 months. Then at the time of jury selection, he said, I want the PD back. And the trial court denied counsel. That got reversed on appeal for the refusal to reappoint counsel. This is not a case like many that were cited in the state's brief where Mr. Brown was going back and forth between counsel and no counsel. This is not a case where he went through 6, 7 different counsels. This is a case where he had one appointed counsel that didn't do what he wanted to do, so he decided to represent himself. He represented himself for 16 months before a pandemic hit. In that time, he did a deposition. He conducted a motion to dismiss. He did a motion for rehearing. He requested discovery. He was preparing for trial just as any other licensed attorney would do. At no point did he continue the case for the sole purpose of hiring an attorney. To say that because it took this long, he automatically should not get an attorney makes the rule lip service, irrelevant. The rule is there for a reason. The Constitution says it. In Brown, they say he has the right, even if it's at the last second, to request counsel. And in U.S. v. Chronic, they talk about it could be even done mid-trial. Here we had it before the jury was even selected. And what correlates with the third issue is something the judge said at the docket sounding, and then he said initially before the veneer walked in. It's 5 years, discovery is done. He said it once at the docket sounding, and he said it twice when Mr. Brown first said, I need counsel. The state, during that veneer, prior to the veneer walking in on jury selection, sat quiet despite knowing it had additional discovery. Discovery wasn't done. Had the court appointed counsel, those things could have been worked on, but he didn't. And Mr. Brown, being a pro se litigant with no legal experience, no education beyond maybe some college, it was just said he made it to college, so it's unclear how much college he actually completed. He doesn't know the rules, he doesn't know the procedure. So you have the state laying in wait with additional discovery, hearing the judge say, everything's ready, we're good to go, and then they spring the discovery. It just goes to show why it was so important to reappoint counsel. And again, as stated in Brown v. State, there is a presumption against the waiver of the right to counsel. So he should have been given counsel. Once he was denied counsel, the problem was exacerbated and is, as addressed in point 2, when Mr. Brown was excused from the courtroom. Once he's excused from the courtroom, he's now no longer represented in front of that jury. They did a voir dire, and more importantly, the actual selection of the juror without any representation from the defense. It became a one-way trial.
Why he was excused from the courtroom?
He was excused for outbursts.
Because you don't mention any of that in your brief.
Yeah, I believe I do.
Okay.
But even irregardless, as I argued in the brief, the right to represent yourself can be revoked. And that was discussed in Chronic And that was discussed in, I apologize, footnote 46 of Ferretta, where it said you can revoke the right to self-representation, and they cite to Illinois v. Gates, in which that is exactly what happened, is the trial court appointed standby counsel to represent the defendant while the defendant was having his outbursts. Instead of appointing standby counsel, which is the one thing standby counsel did do in this case, is when Mr. Brown was excused prior to the lunch break, standby counsel mentioned to the court, hey, this is a little different. He's not, if you exclude him, he gets no representation. And the trial court said, well, I need to do some research, and it was never brought up again. We had, in essence, an ex parte selection of the jury, and then we had 5 witnesses called completely without subject to cross-examination. 1 was still on the stand when the trial re-began the next day, and 2 overstayed objecting to being able to do so. The trial court allowed him to call as his own witness for the purpose of impeachment. So you had a situation where you pick a jury
Was
and
he
you
given
had,
the opportunity, though, to come back in? It's not like he was excluded and that's it. Didn't
he
the
was
trial
given
judge?
he was given multiple opportunities to come back in. But like I said, like I argued, just like competency to stand trial, competency to represent yourself is an ever-flowing thing. And once the trial court determined that he was no longer competent to represent himself, the trial court had every right to revoke the self-representation and appoint standby counsel, which is exactly what happened in Illinois v. Gates.
Then he'd be complaining about that. No.
The case law would support that he would be wrong, because you have the right to represent yourself, says you have the ability to comport your behavior to the courtroom rules and norms. And once the trial court, and the trial court himself admitted to it, if I had to do it over again, you would not be representing yourself. So the trial court admitted he was no longer able to comport his behavior to the norms and rules of the courtroom. The trial court, you throw that in with him requesting counsel.
Unable or unwilling?
To me, they're the same thing, Your Honor. If you're unwilling, you look at Jones. That's an individual who was able but unwilling to comport his behavior. But the difference in Jones from this case, Jones, he asked for counsel on the second day of trial, and he was asking for a specific attorney. He wasn't saying, I'll take standby counsel. He was asking for things he couldn't get. Mr. Brown did not do that. He said, if I've got counsel here, what's the problem? There's nothing to indicate he wouldn't have accepted Mr. McClellan as his counsel. So you not only
Other
have...
than his past behaviors.
What past behaviors, though? At every pretrial hearing, he behaved himself admirably. There's never an outburst in any of the...
I'm not talking about his behavior, his back and forth. I thought the trial judge was quite patient throughout this. Trial judges were quite patient with your client throughout this years-long process with a person who I think looks like they kind of got a good measure of as they went through the proceeding.
I'm not saying the trial court wasn't patient, Your Honor. And you talk about the years of the trial. The first 11 months, he was represented by private counsel who didn't do anything. He then went through 4 months of various counsels who had to withdraw due to conflict. He then had a few months of Mr. Davila before he went pro se, because wrongfully, and I'll fully admit he was wrong, he wanted a motion argued that Mr. Davila said he didn't have grounds for, so he wanted to represent himself. Even if you read through the transcript of the motion hearing, he handles himself very well. He's not having outbursts. So it's not a situation like Jones where the client is having outbursts. But he wanted counsel. And he wanted to exercise his right to counsel.
Did he ever request Mr. McClellan be appointed counsel?
No, I don't believe he ever, he never mentioned him by name, but again,
The request was basically someone that it would take 6 weeks to get on board, right?
it might have taken less. As the court said multiple times, the discovery is completed.
Wasn't there somebody who was a non-lawyer who kind of acted as his spokesman at one point?
And
said,
unfortunately,
hang on just a
yes.
second. And said that they were talking to somebody, but it would take about 6 weeks to get them on board?
And that was the non-lawyer that came out later. It was his aunt, Miss Janae George. She's the one who testified at the motion. I use the term testify loosely. At the motion to dismiss hearing, she appeared at sentencing, and she did appear, I believe it was before opening statements, when they had another discussion as to the request for counsel. And she said that the family was trying to hire another attorney, yes, but they hadn't actually hired one. And because Mr. Brown was in the box, which there's no dispute, he had no access to his materials for the 3 months leading into the trial. He had no access to the outside world. He said unless you were counsel of record, they wouldn't even let him talk to an attorney. So he has no ability for 3 months leading up to the trial to even contact an attorney to hire them, or worse off, look at his own record. He couldn't even look at his own discovery for 3 months leading into the trial, which again would lead one to think that someone going into that situation would be that much more nervous, having not reviewed any of their material for 3 months, and lo and behold, here comes a jury of 50 people that they got to pick for a first-degree murder. But once you have that request and you remove them from the courtroom, it's a doubling down on the constitutional error. And that gets further because the state relies on the standby counsel to prevent egregious errors, but standby counsel said nothing about the discovery violation, which can be no doubt an egregious violation, right as the veneer is about to walk in, saying, hey, here's 2 new terrible statements, highly prejudicial of the defendant, and the court's response was, we can handle that at cross-examination. And when the defendant does try to talk about it, he says, this isn't the time for that. And that goes to issue 3. However, unless the court has any more questions for me, I'd like to reserve the remaining time for rebuttal.
Okay, thank you.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. First of all, let me address this discovery issue, since that's what he ended with. Opposing counsel said that the prosecutor was laying in wait with this discovery, and he should have disclosed it at the October 20th hearing. Well, that would have been impossible to do because he talked to the witness on October 21st. That was the first time he heard about these statements, and then the first time he could see the defendant, he told him about it. That's not a discovery violation. And it certainly wasn't raised as a discovery violation before. And pro se counsels held to the same standards as professional lawyers are. They have to preserve issues, and he was warned about that multiple times. He didn't preserve this Richardson issue. I think the key statement here, Your Honor, is when the court asked him, Mr. Brown, are you deciding today that you don't want to represent yourself, that you want counsel to represent you? And the defendant said, of course I don't want to represent myself, and I never planned on representing myself. Yet they spent 3 years with multiple hearings where the court practically begged him to get an attorney, begged him to let Mr. McClellan represent him, said he was a fair lawyer, he's a great lawyer, he cares about his clients, I know you were burned by a lawyer before, but this guy is a good guy. And the defendant said, nope, I want to represent himself. And you know what? He has a constitutional right to do that. And the trial judge was required to acknowledge that constitutional right. He was competent to represent himself. The court never changed its mind about his competency. He changed his mind about the wisdom of doing this when it turned out that this guy was quite a troublemaker once they got the jury in there. He had always been fine at the hearings. The court had no grounds to take away that constitutional right to represent himself. And there are consequences that come with those rights. And one of the consequences is if you manipulate the proceedings, you don't get a continuance after 6 years after the crime. On the day the jury is sworn, you can't come in and say, now I want a lawyer. He first started hedging about whether or not he should have a lawyer 2 years earlier. He had 2 years to decide to get a lawyer, and all of a sudden the day of trial he says, yeah, now I want one. He just was seeking to delay, and the trial court made a specific factual finding that this was not a genuine request for trial counsel, that it was disingenuous, and he was just trying to delay the proceedings again. This was a remarkably patient judge with a very, very difficult defendant, and he handled it as best he could under the circumstances. He certainly acted well within his discretion in warning the defendant when he started acting up and bringing him back in, no matter what kind of shenanigans he was pulling. And, you know, once the defendant realized that he wasn't going to get a delay, he settled in and he represented himself competently for a pro se defendant. So on this record, there's just no abuse of discretion here. The trial court wasn't denying him his right to counsel. He kept saying, get a lawyer. You can have whatever lawyer you want, but you can't get a continuance. And as Ms. George said, we tried to find a bunch of lawyers here at the last minute, and nobody would come on because they knew the judge wasn't going to give them a continuance. As far as Mr. McClellan goes, the judge asked him if he was prepared for his role to be as lead counsel, and Mr. McClellan said, no. I have been standby counsel. They have talked about this repeatedly at hearings where Mr. McClellan said, I'm happy to represent him, but he doesn't want me. And he, at the last minute, wasn't competent to represent him. He hadn't engaged in discovery. He was standby counsel. He was there to schedule the hearings and to answer his questions, not to go through discovery and prepare for trial. So he was offered Mr. McClellan. Mr. McClellan said he couldn't do it. That's a consequence of the defendant's actions. He delayed for years and years. At some point, everyone has a right to a trial, including the state, including the victims' families. The co-defendants were waiting to be sentenced. They had entered pleas years before. And let me just
You mean
add.
the state has a right to due process?
Absolutely, Your Honor, yes.
Yeah. Make
and
sure you point
let
that
me-
out if you ever get up in Tallahassee, in front of the Supremes.
And let me just add, as far as COVID goes, certainly he did not go to trial during COVID. Nobody did. There was a year delay, during which time he could certainly prepare for trial or try to find a counsel if that's what he wanted. It's not like everything was on hold, just trials were on hold. So that did contribute to the delay, but it certainly didn't contribute to his lack of preparation. He was in the hole at the jail a lot because he kept fighting with the gang members in the jail, not because the trial court put him there so he couldn't have access to his materials. Again, with rights come responsibilities. The defendant asked way too late to have an attorney. He was manipulating the system. Case law is clear, you can't do that. And if the court has no questions, we would ask you to affirm. Thank you.
All right, thank you, counsel.
There's no evidence that Mr. Brown was manipulating the system. I find it funny that they're relying on he didn't have access to his materials because he kept getting into fights in the jail, which shows he can't comport with his behavior with the jail rules. You have a court who's already saying it's clear he's not going to comport his behavior with the court rules. Again, the court he has the right. You have to have an adversarial process. If there's a breakdown in the adversarial process, as stated in Chronic, you don't have constitutional due process. And you had a jury selection and 5 witnesses that went on without any subject to cross-examination. That is a breakdown in the adversarial process. As to the
Well,
discovery,
using your term, for the sake of this question, it broke down because he chose not to participate.
and what should have happened is the trial court should have appointed Mr. McClellan to take over the case, just like the court did in Illinois v. Gates, just like the court in Feretta said the court could have done. Is he could have said, okay, Mr. Brown, you're not going to comport your behavior. Mr. McClellan, your counsel. That's what should have happened in this
Had already
case.
said he wasn't ready to proceed.
That's not Mr. Brown's fault. That would have been a different issue. But once Mr.
Well, it's not Mr. McClellan's fault either. I mean, his role,
well-
excuse me, please. If your client keeps saying you just be standby counsel, that's what you get ready to do, is to be standby counsel, deal with legal issues, give him advice on things. You don't prepare as though you're going to go try the case.
And I don't disagree with that. However, going back to that June pretrial, the court delayed it and said, Mr. McClellan, I want you to meet with him to discuss if he wants you to take over the case. If you've been through some of the problems
They
that Mr.
meet and discuss it,
The record would say that they did.
and your client didn't choose to have him take over the
At
case.
the time, he wasn't sure. He wanted to try to find another attorney.
Your client didn't say, please take over the case,
No, he
did
did not. Not at that
He could
time.
have if he wanted to.
He could have, absolutely.
He
He
did
could have done
not.
it 2 years earlier.
He did not.
No, and there's no rule, there's no law that says he
Why
has to
should
do it
Mr.
at a certain
McClellan
time.
have prepared for something that he wasn't going to do?
And that your client didn't want him to do.
How can you effectively give advice if you don't know at least something about a case? That would be my
There's not-
response to that.
I didn't hear he knew nothing about the case.
Well, actually, I would disagree with that because he said, I didn't look at any of the evidence. I didn't look at discovery. If you don't look at any of the evidence or discovery, how do you know anything about the case?
Well, what is he supposed, I mean, he's standby counsel to say, okay, you're going to be there to help the guy if he has any questions during the trial. It's not your job to prepare
And my
for the
counter
trial.
to that is, if you're asked to talk to a client about possibly taking over a case, Isn't it reasonable to think that attorney will at least look at something so he knows a bit
Well, why
about it
don't,
before?
maybe it's reasonable to say, okay, Mr. Client, or Mr. Brown, or, excuse me, Mr. Brown, before I start spending my own time looking at the case, we've been through this dance quite a lot, I've been told by the judge to talk with you, do you want me to take over the case? And apparently the answer was no, up until the morning of that Mr. Brown said, uh-oh, guess what, this might actually happen, so now I have a change of heart. Isn't that exactly how the record reads?
For the most part, yes.
Okay.
It's not entirely clear that he said, no, it's not at this time. But, and again, my counter to that, just as stated in Brown, he has that right to do it at that last set time. It's stated in Brown. Brown relies...
But then the trial judge decided, I guess, determined that your guy was being somewhat disingenuous, and that, so he
And
decided...
I disagree. I think the facts of the case, the procedural history, are very much like Brown.
I'm sorry to interrupt you, but what of the comment that he did make that stuck out to me, obviously stuck out to your opposing counsel, that he never really planned on representing himself? I mean, that's not a slip of, maybe a slip of the tongue, but that's not a misspeak.
I think that's a frustrated defendant who's gone through a lot, and I don't think it's a misspeak. I think
Or the trial judge could say, ha-ha, so we do actually see what your intent was throughout all this. You never planned on representing yourself, but you certainly have indicated to everybody that had been your plan all along until the morning of trial, and that's why perhaps the trial judge figured that this was not quite a genuine request.
And my counter to that is, when you look at when he first went pro se, even when Mr. Davila was still on the case, he wanted that hearing had. It is clear he went pro se to file that motion to dismiss. Once that got ruled upon, I think the I never wanted to represent myself probably would apply. However, because Mr. Davila was unwilling to file that motion, I think his initial request to represent himself was absolutely genuine, and it shows because he not only had a hearing before the motion, he then filed a motion for rehearing on the motion. He clearly wanted that and felt strongly, unfortunately due to the bad advice of Ms. George, that was reversible error. As to the state's argument of preservation as the discovery violation, the law is clear, magic words are not needed. Once the state said, we have new discovery, Your Honor, that put the court on notice that this was a discovery violation. It is a discovery violation. This court has held before. The law is clear. If you disclose additional statements of the defendant at trial, that is a discovery violation. There's procedural prejudice. And even if this court were to find that the state's own words didn't put the court on notice of a discovery violation, once the defendant, who's an untrained person, says, I want to talk about what my co-defendant, can we talk about what the state said? The court's response was, this isn't the time. Actually, yes, it is the time. Because once the court is put on notice of a discovery violation, it is required under law to hold a Richardson hearing. And this was a discovery violation. It was egregious. It would have resulted in most likely a minimum of a second deposition and possibly a continuance. And this court has reversed, in very similar situations, discovery violations just like this. And we'd ask that this court reverse and remand for a new trial in which Mr. Brown have the entitlement to counsel. Thank you.
Okay, thank you, counsel.